My name's David Payden. It looks like Peden, I say Payden,
Sorry.
but I answer to both. My family's been mispronouncing my name for generations, you know. I'm here as Teal's counsel today. I'm also a property owner here in Rockport and have owned property on Key Allegro for more than 30 years. So I'm a taxpayer here too. I care about Teal. I care about this project. I care about this community. As a lawyer, what I do is construction law. And I've been doing this for my entire career. And I'm very proud to say that been elected as chair of the State Bar of Texas Construction Law Group. Believe it or not, there's over 2,000 dues-paying construction lawyers in the state of Texas. None of them are here in Rockport, but we have them around the state. But Texas decided that we needed to up our game a little bit. And so as lawyers can be board certified in civil trial law, criminal law, family law, and so on, we also have board certification for construction law. And the state of Texas needed some senior lawyers to design the qualifications and then design the test, run the test, and grade the test. And I'm one of the 6 lawyers from around the state that did that. So all of the board certified lawyers in construction law in Texas took the test that I wrote. So this really is what I do. I'm here this morning to give you a brief response to a memo that was presented to you by the county attorney earlier in the week. And some of the things that are in there are just flat not accurate, and I think you need to hear the other side. I want you all to understand that there's some things that were said in that memo that if you just follow the memo might lead you down the wrong path. So thank you for the opportunity to say a few things. First, Teal's goal is not war. I'm not here to pick a fight. I'm here to keep the Humpty Dumpty together. We don't want the egg to break. Teal wants to finish this job. You'll hear that from any Teal person all day long. But there's some disputes between us, and we have to deal with them. One of the things addressed in the memo is how the brick and the soffit turned out. Teal came up with a solution that was generated by a design issue, a design conflict in the architect's design. It all started with whether or not there's going to be slivers under windowsills at the second-story level in the field of the brick. The contractor made an adjustment when the architect complained. Now the architect doesn't like the way it turned out. It's de minimis, to use a lawyer term. In plain English, it's not important. Nobody sees it. It's on the backside of the courthouse. It looks fine if you just look at it. And if the brackets at the top vary between 8 inches and 11 inches, and they do, we admit that. You had to adjust somewhere. You can't see it. You'd have to be an architect and be looking for it to see that problem. So we were told, tear down the whole brick wall, take off all the stucco, take off all the ephes, take down the tile, redo everything. That's $1 million problem in 6 to 8 months worth of work, and it makes no sense. Your county attorney says we should have done it. We cite a case law that says, including a courthouse case, that says that no, that's not the law in Texas. You don't do solve a little problem with big expensive solutions like that. It's economic waste. Your county attorney has not cited a single case to you that says my cases are wrong or that I've said it wrong. So that should be water under the bridge and should be a non-issue at this point. Elevators. The county attorney's taken the position that the elevators are Teal's fault. They're not. The architect specified a particular manufacturer, Coney, but Coney refused to supply. If the architect had checked with Coney and found out that Coney was not going to supply elevators to this location, their reason is they can't provide service to the elevators in this location after they've installed it. They're just not set up in this area. We wouldn't have had this problem, but because Teal found the solution with a different elevator system, which required some redesign. The design process undertaken by your design team took months, and that in turn delayed other long lead items like electrical. And so that domino effect actually took so long that the elevators got pushed into a new code. A code change happened in the middle of this project, and some additional work had to be done. The elevator inspections are going to be in the next couple of weeks, we think. and they should pass. So the work's all been done now, but the delays are not Teal's fault. And there's a provision in the contract in the A201 at 3.4 that says that Teal's not responsible for errors in the plans and specs. Specifying Coney was an architect's mistake. Teal never picked it. So that's not Teal's fault. And under 8.3 in the A201, we're entitled to those delay days caused by this change that was necessitated by a mistake by the architect on the front end. Windows. This is a big deal, and it's going on right now. Your county attorney assumes that it's Teal's fault. Again, we disagree, and we have hired not one but two experts, including David Nicastro, who I've worked with for more than 30 years, who's a professional engineer, and he is so good at sealants that he's on the board of the institute that deals with sealant specifications. He runs his own testing lab, and he has all kinds of data on what sealants work and don't work. If you look up David Nicastro with ABB, you'll see this is the real deal. He's the real guy. Every single window that was, yes.
Usually under citizens to be heard, you let them speak for 5 minutes. Your 5 minutes have expired, but I would suggest that we might let you continue to talk if we add you under items for deliberation, presentation of attorney letter to Aransas County Commissioners Court.
That'd be fine. I'll stand down and come back then and pick up where I left off.
That's fine.
Thank you.
Thank you.
That's all. Anybody sign up online? All right. We're going to move on to presentation of attorney letter to Aransas County Commissioners Court. Morning.
I don't know what you're going to hear today from everybody else. I don't like that uncertainty. But I know what you're going to hear from me, and I believe that I'm right, as every attorney who stands in front of you today believes. Sure. Is this any better? No? Okay. I'll speak louder. It's fine.
Please.
My goal with writing you this letter is not to say right or wrong, is not to point fingers, is not to say it's not our fault, although I do say it's not our fault. My point is to bring you up to speed from the legal standpoint of what you are owed and what belongs to you underneath the terms of the contract, all of the contracts, okay? So I would just say reasonable minds can disagree, but I would also say I think there's probably at least 3 attorneys in this room who are a member of the construction law section of the bar. I know I am. So anywho, I think we just need to hit some highlights today. I think it's possible to get into the nitty-gritty, but I don't think we have to go there. I think today can be really positive. I think that we can work with the people whom you have hired. And I know that's a really bold statement because it doesn't feel like that right now. I hope you feel that way once I'm done. Just to be clear, we're not going to resolve everything today, and that's all right. We can have another workshop if we need to. But I can sum it up. I never have good news, and I rarely have a direct answer, and this time I have both. I think that we can follow the contract and follow the law and save money. And I don't know about you, but I like hearing those things. So just to breeze through some of the things in my paper, base scope work. Okay, this is a lump sum contract. The way that works, it's pretty standard as contracts go. The way that works is that Teal got a copy of the designs. They got the opportunity to bid it out with their subcontractors, and they came up with a number they were happy with and a number we agreed to. If any remaining work is base scope work, it's already been addressed. But I'll go one step further. The Constitution for public entities like us is Article 3, Section 53. If we've already started a contract, we're not allowed to give more money unless there's an exchange where we get something too. So that one's pretty hard to get around, but those are the rules. So I'm just going to move on to the next one. For non-conforming work, there's a handful of concepts I want you to understand. I like to think of things if I have a visual representation. So the first one is final completion. If I'm going to drive my car from Rockport, Texas to Disney World, final completion is Disney World. Substantial completion is making it all the way down I-10. I've made it to Florida. I still have to drive the body of Florida, but I've made it to Florida. We are not to Florida yet. Second one, non-conforming work. I like to think of these as people. Non-conforming work could be a gentleman who has graduated high school. He has not pursued a trade. He has not pursued college. He has a part-time job at a fast food restaurant. He still manages to play 16 hours worth of video games every single day, has no bank accounts in his name, still gets an allowance and lives in his mother's basement. That is non-conforming work. You are entitled to conforming work. That gentleman has a job job with insurance, with benefits. He has bank accounts with money in them. He has a Roth IRA. He serves in the community. He loves kids, loves dogs, loves your mama. He is marriage material, and that is what you're entitled to under the contract. People are offering you non-conforming work. You shouldn't take non-conforming work. I'll get back to that. Okay, so we have the difference between substantial completion and final completion, the difference between conforming work and non-conforming work, and then we have what I believe shows Teal's character. There is a reason that you decided to work with this company. And I believe that you can find that in the contract under section 12.2.1. And I quoted in this paper, and I don't need to, the real world way to say it is, if it's not right the first time, we'll fix it for free. That's the kind of company I want to do business with. I'm sure that's the kind of company you want to do business with. But they also say, in I think it's 3.5.1, they have 2 warranties in there. These are not the warranties after the work has been complete. These are the warranties you take to court. And I hope we never have to get there, right? But it says their work will be good, of good quality, and new. It says the work will conform to the contract documents. And then a little bit lower, it says if it doesn't, you can call it defective. And I think of that as them saying, we're going to build this right, and it's going to be so good that someone can come look at it, and if it's not right, we'll fix it for free. But also, we're so confident it's going to be right that if it doesn't match, we'll call it defective because they agree to these terms. So we're at a place now in 12.2.1. It's before substantial completion. The architect has rejected the work. Teal has to fix it, and they need to pay. So that's one scenario. We get into a couple of different variants, if you will, because what if that happens, but Teal says, we built it right, but the design is wrong. Maybe that happens. I'm not saying it did. I'm just saying, what if it did? Then what do we do? Well, we're going to have to hear from the architect. We're going to have to hear from Broadus, and someone's going to have to make a decision. If Teal is right, they built it correctly, and it's not their fault, then maybe they're entitled to some delays. Maybe they're entitled to some general conditions while they had to wait. That's a reality. Okay. That would fall on us to pay, and then we would need to turn to someone else and say, hello, architect. Hello, Broadus. We hired you so we wouldn't be in this position. You might owe us money. I'm just telling you that's a solution. Maybe we get there, maybe we don't. Okay? So, if we're in a situation where there's non-conforming work and Teal has said, we built it right, and the architect said, but we told you along the way, okay, now we might be getting to where we're butting heads. But someone will be right, and someone will be wrong, and you didn't design it, and you didn't build it. So it's not your problem to solve. Someone else should solve it. You've hired professionals to do exactly that. If you do have to wade in, I would put this as another real world example. For every child who grew up in a 2-parent household, if they asked mom and mom said no, so then they asked dad, that dad is going to say, what'd your mother say? And that's what you should do too, because there are some circumstances today where the architect has said no, where Broadus has said no, and now Teal's coming to you saying, well, you need to tell us what to do. And I would recommend that you say, what did the architect say? Because you're entitled to rely on their professional advice. So that's a legal statement that makes people nervous because it could transfer to dollars, right? But at the end of the day, it needs to be resolved. And if money's the only way to get it resolved, so long as the county doesn't end up as being out of pocket, well then, okay. So money might have to change hands. We might have to come to an agreement today about how money changes hands. And I want you to know that's allowed by the contract, and it will be okay. Because if the county's in a position where they have to pay out, the county's also legally in a position where they can get reimbursed. That situation is very similar to Teal. All right, so when I told you, Teal told us what their character is. If it's not right the first time, we'll fix it for free. I've read 76 of their subcontracts. They have language in those subcontracts that says, Teal is allowed to reject your work. The owner's allowed to reject your work. The owner's representative is allowed to reject your work. We hired you. Our reputation's on the line. We told them if it's not right, we'll fix it for free. But if you're the one who messed it up, you're gonna pay us back. That sounds fair. Anybody who's ever been in business understands if you subcontract something out and the subcontractor gets it wrong, they're gonna be on the hook. For the masonry, for the brick installation, TM Work Zone Masonry has that term in their contract. So we're in a position where the architect, where before substantial completion, the architect has rejected the work. Teal has to fix it. They have to pay, but they have a remedy. They have a remedy, and that remedy is so good that it says, you're going to pay for everything, Mr. Subcontractor. And if we get sued, you're paying for our attorney's fees. And if we have to pay liquidated damages, you're paying that too. I mean, I'd be pretty proud of that contract because that's a nice position for Teal to be in. But they are in that position, and you might not know that because you might not have read their subcontracts. I believe there are more than 76, but I've only ever received 76. So I can't tell you what else might be there. You have the option to accept non-conforming work. You do. Legally, under the contract, you have the option to accept non-conforming work. I would not recommend it for the sole purpose of it translates to dollars, whether it's current dollars or future dollars. And those future dollars might be gigantic. If you have the opportunity to choose between non-conforming and conforming, non-conforming might get you in the door faster. There's no disagreement with that. The problem is when you get there, there might be problems you don't know about that you only find out about later. When you accept non-conforming work, you could be waiving your right to sue. That's going to make every single attorney who's not me in this room give a sigh of relief. Because we don't know what we don't know, and we don't know what's really in that building. What we do have, what I have in that stack of papers over there, I have change orders that say, remove sheetrock from these 4 rooms due to mold. I have a report from Architectus saying, remove that wood at the top 40 feet in the air where nobody can see because it's got mold. Mold, unless it's completely removed, multiplies in a humid environment. And we live where the ocean is right there. It's 200 yards away from the building that is being built right now. There is humidity every single day, except for maybe today because my hair looks really good. But this is a natural indicator of humidity. So we need to know, how do we know if there are things we should know before we accept your non-conforming work? If the goal is to get in the building, okay, so let's address that. If the goal is to get in the building as fast as we can, how do we know that we can get in there safely? Because sometimes we can accept non-conforming work because it might be something we can fix. If it's sheetrock and we know we have people on the facilities team who can do that pretty well, that could be a perfect example of how you accept non-conforming work. So it's available to you. But before you make that choice, you have a remedy in the contract, and it is 13.4. 13.4 allows the county, without anybody else's input, the county. It allows the county to decide, we want an independent inspector to come in. And we want them to look at these things that we're worried about. And if they tell us it's okay, we're going to do that, and then we'll accept the non-conforming work. When I bought my first house, I did not rely on the inspection of the person who was selling the house. I had to pay a mortgage. They told me, if you want this house, you need to produce an independent inspection report. So I went and hired someone out of the phone book, the first one who answered the phone, who could come check out the house, and he made me a little report. And that was enough for me to know, hey, this house isn't perfect, but okay, it's fine, and my mortgage company will accept that, and my insurance company will accept that. I'm going to go forward. I did not go to the architect's inspector or the seller's inspector or the realtor's inspector. I went to my own. You have the option to do that. I think you should. And I think you can make that decision, and you can start calling some people, and they can put together a report for you. I believe that it can be relatively short. Teal can still complete their work because you are not getting in their way. They're 100% in charge of their own schedule at all times. That's in Article 3. At all times, Teal is in control of their schedule, their sequencing, their means, their manner, and how they run their subcontractors. And you are allowed in Section 13.4 to call in your own inspectors, and they're not allowed to get in Teal's way, but I also don't believe practically that they would get in Teal's way. If you're worried about cost, I would suggest finding the money. But also 13.4.3 says that if they find something, then we're allowed to go get that money back. Also, I would recommend following 2254, which is the professionals, how the county procures professionals. I think we follow that. Under consultants, we're allowed to hire people. We might not have to follow the regular 60-day bidding process. We can just hire people as consultants. And I think you should. But then also, if you have that report that says this is good enough, I think everybody can be reasonable. Everybody can be reasonable and say, we're going to rely on this report and move on. The county's going to accept what they want to accept. And if they do, and it relieves them of the ability to sue in the future, then that is at least an educated decision. Everything else in the meantime can keep going. Everything can keep going. It should keep going. We might be here to talk about things that are a little bit sticky. I would recommend that we don't rehash history, right? So if we're just at a point on non-conforming work, everything that's under section 2 in front of you for the agenda, follow the contract. Before substantial completion, has it been rejected? If that answer is yes, then we move on. Teal has to fix it, Teal has to pay. If Teal has a valid excuse, such as we built it correctly, but the design was wrong, okay, then you need to hear from the architect. And then you need to ask the architect, why was this wrong? Are they telling the truth? Is it really wrong? Have you brought in a consultant of your own to say, no, it's really all right? So some of these are fact questions, but I don't think that you need to get into the history of what happened. You can, but it might make this workshop be a very, very long workshop. And so that's why I'm saying I don't think you need to. You've hired professionals, and they can give you very quick and precise answers. One thing I forgot to say is there might be some things that are sticky, okay? If it is a delegated design, most of the time the architect is going to be in control of everything, design-wise. And ultimately, the architect is in control of everything design-wise. But if it's a delegated design, Teal might have had the option to design it with their own designers. So if it's before substantial completion, the architect has rejected the work, Teal has to fix it, they have to pay, and they said the design was wrong. Well, if they're responsible for the design also, they still have to pay. And we keep moving. Okay, if it's a substitution, depending on the subcontract, first of all, the substitution is a representation by Teal that they have vetted this option. In the supplementary conditions, Teal is accepting any extra cost that comes with a substitution. So if they recommended the substitution and then there's extra cost, we're done. Because that's in the supplementary conditions, and they said they would accept all of those extra costs there. Nobody likes that. Well, people, not the county, don't like that answer, but that is the answer. Again, I finally have answers for you, and it saves you money because you shouldn't have to pay, right? You need to ask, what is a substitution? What is a delegated design? That's a fact question, okay? Because that's going to help us get to the answer of who pays and how do we move forward. That's all we really need to know. How do we move forward? How do we get in the building? I think you have options in front of you today that will entitle you to, if money is supposed to change hands, that you don't have to ultimately pay. Okay? So there's lots of people with lots of motives who are going to stand in front of you today. Maybe they're attorneys, maybe they're not, and they're all looking for a way to not have liability. I understand that. I understand that as a person. I bet you do too. But at the end of the day, these things were promised to us, and it was promised to be done well. It was promised to be done correctly. And they even looked ahead into the future to say, and if it's not, these are the rules of the game, and this is how we're going to engage with one another, but the work doesn't stop. So if the work has stopped, something's wrong. I will be right there if you have any questions during the rest of this workshop, or if you have any questions for me right now. Yes, sir.
First of all, I just wanted clarification. Are you board certified in construction law?
Of course not.
Okay, because I misunderstood what you were saying.
No, you can be a member of the construction law section,
Okay.
and then you have access to their library and their articles. I'm going to their conference
Okay.
next week.
And the other is you mentioned Arctic, Texas. I was wondering what construction partners are here. I see Teal here. I think I see Broadus here, but I don't, because as members before, we really didn't get involved with who's who. So
Sure.
is Architects is here, and is Broadus, I mean, it's, PGAL is here, but is Broadus here?
Yes.
I would be
Broadus is here,
incredibly
and is
surprised if Architectus is not here online, if they're not actually here in person.
Are they online? No.
They're not available.
We can ask, and if not, if they are available and we can send them a Zoom link, we'll send them a Zoom link.
And I guess the other,
I'm here from PGAL, so I'm representing the design team, so I can speak to the
okay,
architect design team.
okay, and you made a comment about hiring an outside consultant. I thought we already had been using a
No,
consultant.
she's talking about a third-party inspector.
Okay,
Yeah.
okay, thank you.
I'm not sure what microphone is doing that sound, if it's yours or if it's this one. So I'm gonna push this one away.
Questions, gentlemen?
Just in case.
Okay,
Anyone?
Thank you.
thank you.
Okay.
I do have a comment. When someone's up here speaking, gentlemen from Teal, please refrain from making faces and shaking your head and all that. Thank you.
Point of order, Judge, Ms. Martinez had 20 minutes, or actually it's about 21 minutes, 36 seconds. And you and I had a discussion yesterday about the format of this meeting, and I would like to make the request that we have equal time to
Okay.
respond.
All right.
Point of order, I'm doing presentation, which according to our rules of decorum right here.
We up to 30 minutes.
This is a workshop.
It is a workshop.
I just want to make sure that we get equal time to respond. If it's 30 minutes,
Just refrain from making faces. It's kind of rude. And, you know, when Mr. Payton was talking, nobody made faces. It was just kind of rude. All right, we're going to move on to remaining base scope of work. Mr. Monreal, were you going to hit that?
Well, were we going to ask Mr. Payne?
Oh,
if
did
he
you want,
wanted to
oh, okay.
respond to
Mr. Payton, would you like to,
I would.
what do you want, 20 minutes, 30 seconds? What was it?
21 minutes, 36 seconds, 0.76.
For him to respond?
We have time.
He probably did,
Oh,
but I had 23 minutes that you took.
There's some things that were just said that I agree with. We want to finish this job. We want to finish the whole job. We want to have the work that was de-scoped from our contract put back in. And we
Can I
do.
stop for just a second?
Yeah.
Can we move the podium over here a little closer where I can hear? I just feel like I can't hear you. That may or may not help, but I sure like to try.
Okay.
That's good. That's good.
Is this better?
Yeah,
And I can speak up too.
good.
All right, so we agree with the county attorney that we want to finish the job. We really do, and I mean that. I've been representing TIF for more than 30 years, and they've never failed to finish a job. They've never been terminated from a job, okay? They don't want this to be the first one. They don't want it to ever happen. She mentioned character. I've known John Murray for more than 30 years, and I've never seen his character be bad. His character is to solve a problem. She said that we need to solve problems that are Teal's fault. So far in this job, there's been a bunch of problems that were Teal's fault. Every single one of them has been fixed. Where we disagree on, there's a few that we're stuck on that we don't think is Teal's fault, that we think is a design problem. Where I broke last time was I was starting to talk about the windows. That's a perfect example. Our consultant, David Nicastro, the professional engineer I was talking about, has determined that if the windows are installed perfectly as shown on the drawings, they're still going to leak. And the testing labs proved that, because even windows that were reinstalled as shown in the drawings and the reinstallation was approved by the window manufacturer standing there watching it, it still leaked. Now, y'all know we're talking about a tiny amount of water that gets in. It's the teaspoon amount of water that comes in the corner. Tiny amount. What Nicastro figured out is the problem is that the interface between a piece of metal on the outside of the window perimeter called the brick mold and water coming in literally through the brick during this suction test. Y'all understand a vacuum chamber is set up to suck, see if we can suck water in. And it comes in and there's the problem. Nicastro figured out a solution. The solution has been tested multiple times and it has passed every time. So original installation fails every time. solution provided by Teal and the Castro passed every time. It's simple. We've proved it. But we're still waiting on approval from Architectus and PGAL. Go do it. We're waiting on that. Why are we waiting on that? In the City Hall project, they've told us, do it. Let's test a bunch more windows. And then test 20% of the remaining windows, and then we'll bless it. Okay. That has not happened on your project, and I don't know why you're not being treated the same. That's a question for Mr. Bonnet, and I have not had a chance to ask. But Teal's waiting for direction. We can't just go do it. We need approval to go do it. Now, testing. She mentioned testing and y'all getting an independent consultant. Great. We would love to have somebody really independent who doesn't have any skin in the game come in and take a look at it. We think that's a great idea. As long as they're fair and they talk to the architect, they talk to Broadus, and they talk to our team. Great, let's do it. And maybe that will help you all resolve some of these issues. I also agree with the county attorney that let's finish the job first and then see if we can resolve it. What we're doing with the city is a mediation. Mediation is at the end of this month on the 28th. And we've hired a great construction lawyer who's familiar with this kind of stuff named George Baldwin out of Austin to do that. We would propose the same guy here, or if y'all want somebody other than the one the city picked, we can pick somebody. It's not hard to find a good mediator. Now, the county attorney said that you all are not delaying Teal. That's not correct. We're being delayed substantially right now, sitting here today. We cannot finish it until we get things like the window approval, so we can finish that. And once the windows are approved, tested and approved, then we have to do sheetrock. We have to do other things. There may be some sealing involved. We can't let any of those trades do what they need to do until this window issue is resolved. Windows is critical. We need a decision as fast as possible. With regard to some of the other issues, county attorney still thinks we need to replace the brick. That will cost you a year. Why do that? That makes no sense to me. And we can prove, if somebody wants to drill down into it, we can prove exactly why there was confusion on how to do the brick and what the solution was. Now, county attorney says that Teal has to fix everything at no cost to you. Teal's offered to fix the windows at no cost, even though it's not our fault. Now, one of the things where we do disagree, though, there's a provision, and it's interesting that the county attorney mentioned 13.4 in the contract. I was going to bring it up too. I don't know if you know this, but 13.4 first says if the architect wants additional testing, owner pays for it. It's only if the additional testing proves that what Teal's proposing to do fails, then Teal has to pick up that cost. So the initial cost of the testing is to the owner. We can argue about stuff like that. Let's just not argue about stuff like that. Let's get it done. We want y'all to be comfortable with what we're proposing. Let's get the windows finished. That's what we're trying to do. But that could end up being several $1,000s. We think testing 20% of remaining windows is excessive and not necessary. Test 5, test 10. Get it done in 3 or 4 days. It won't be that expensive. And if they all pass, they all pass. If they don't pass, well, then we're wrong. Let's find out. But we want to get that decision so that we can move on with these windows. With regard to the attorney's suggestion that, maybe if there's a problem with the design, well, maybe you could make a claim against the architect or your manager brought us. Well, it's not maybe, it's real. She cites a section in the Texas Constitution that's general. That's not the controlling piece of law here. There is a piece of law in Texas that is specific to counties. Let's see what that says. This is 262.007 of the local government code is specific as to counties. And it says when the county is a party to a written contract for construction, like we have here, and there's going to be a suit, it says, the suit on the contract brought against the county shall identify the county by name and must be brought in a state court in that county, right here. We don't want a suit. but I want to make it clear that she says, let's follow the contract. You can't follow the contract because the contract says we're not going to have a suit. The contract doesn't follow this law that the legislature's already answered, how you're supposed to resolve these disputes. So there's some things about the contract that we would like to resolve that should be lawyer to lawyer. But I invited the county attorney to go to lunch months ago. They refused. They said, not appropriate to meet with you. Just flat refused. So here we are. So please instruct the county attorney. Let's see if we can resolve these contract issues and not take up the court's time with it. And y'all aren't the lawyers. Let us lawyers figure out a simple solution that would include mediation and then litigation if we can't come to an agreement. That's what we want to do. That's the normal way to do it in contracts like this. By that change they made, by the way, they also weakened the power of your architect. In a normal A201 contract, the architect's the initial decision maker and makes decisions, and that initial decision can be important unless a lot of hoops are jumped through. Do you know that the change that's made in your contract by the people who prepared your contract threw all that away? It's gone. And this is the kind of things we need to talk about. What is the effect of that? So we need some guidance for the lawyers to figure out, okay, if Plan A mediation doesn't work, what's Plan B? We think the legislature's controlling, but your contract doesn't say that, so you can't follow your contract. All right, couple more things, real simple. Teal has fixed every single problem that Broadus has brought up so far, except the windows, and we've refused to replace all the brick because we think that's a bad idea and excessive cost and excessive time. What we need is everybody, the architect team, the owner group, the contractor team, to work together to get this thing finished. We want y'all in. We want everybody who's not had a recent walk in the courthouse, please come have it. Let Mr. Miller or Mr. McComb walk you around the building. See it. We're close. We're almost finished. And the smart thing to do is to let us finish. I'll take any questions if there are any.
All right, concerning the windows, you mentioned a second consultant.
Yeah.
So you had a first consultant. Why did you go to a second consultant?
The first consultant identified problems but did not provide us with a clear solution. And my phone rang. I said, well, let's get Nicastro, because I've worked with Nicastro 30 times. And I've used him on several owner projects. He works for me when I'm representing owners. And by the way, I represent the Houston Airport System, Harris County, Hidalgo County is one of my clients. So I represent public owners like you guys. I get this. He's the best I know in the business. I brought him in for a second opinion. I'm absolutely confident in the solution he's come up with. And the testing so far shows he's right.
Right. The first consultant, they did have solutions, didn't they? They said reset the windows, take them out and reset them.
Well, they were talking about how to redo some of the caulking in it. And there's a question mark that's raised in the drawings about there's the PGAL drawings that were given to you show a piece of metal that in an architect's field report said was superfluous. We think that's right too. The first consultant, which is 06, took a look at that piece of metal and but it's not detailed. So we had some pieces of metal fabricated that might solve that problem, but when we brought Nicastro in, he agreed with the first comment by the architect that you really don't need that piece of metal. You got enough metal there. The real issue is where do you put the waterproofing caulking? And the issues about whether a Dow 795 versus Tremco caulk is the right caulk is determined that that's not the issue. The question is where do you put it? And so where he's come up with, what Nicastro has done is put in a new caulking design that should last the life of the building. That's what he says, and he put his engineering seal on it. Says this will work, it works. So that's what we want to do.
So, so the first consultant, did they raise any issues on why there was leakage?
Yeah.
Okay.
He said design time. It's going to leak.
But
one of the solutions to the
were there things they like backer rod? Was there backer rod missing?
Oh no, Teal did not fail to put in backer rod. The only thing Teal didn't put in was the piece of metal that is just shown as a straight line in the drawings that seems to be additional and doesn't really serve any purpose. I think everybody's agreed that piece of metal is not needed. That's the only thing Teal didn't put in.
I did see a picture where they took off some of the trim and the windows weren't even butted up together, so there's a gap. But
There's no gap that any water or vapor can get through when all this work is done, and this work can be done without the necessity of taking the windows out, which makes it fast, which is important to everybody. And some of the things they complained about was, is the gap too big or is the gap too small? We've already determined that where we've got that over 1 inch gap, the manufacturer said that's no problem, and Nicastro has confirmed that.
when did Teal and the city agree on the fix?
Yeah, come on, Michael.
Yes, ma'am.
I don't know, but I feel like the last time that I spoke directly with Vanessa about how the city is handling their contract, they do everything in closed session. So what happens
In closed session stays in closed session. So if any part of this, is only from closed session, we might not be entitled to hear it. I'm not the city's attorney. That would be for them to raise that issue, but for us, I wouldn't want the Commissioners Court to be in any violation of the Open Meetings Act. So again, this is a fact question. If they met in closed session, I don't think we should hear about that.
The answer to your question is there is no agreement that has been struck yet.
Oh.
We have some recommendations. We're going through those recommendations and responding to the architect in the city. But as far as an official agreement, nothing has been struck yet.
Oh, okay. I thought Mr. Payton said y'all found a fix and a solution, and
We have.
okay.
We have.
Have y'all started that work yet?
No.
Oh, okay. You're making it sound like we're way far behind.
Well, we have a program on the city for us to do the fix, test 20% of the windows, and then they'll tell us. That's what they've told us.
Okay.
But we're allowed to go forward and do that with a testing program. We're not yet allowed to go do that and with a testing program here. They've not said the same thing to us they said to the city.
You're asking that they will have the same windows tested in the method that the city is having theirs taken care of?
Well, you all might decide, since the city is moving faster, if we do the city first, and that gets tested and all those pass, that may give you a greater comfort level.
Is that installed, are the differences in installation of the city hall than courthouse?
No, they're all the same.
So if city hall passes, logic would say that, assuming everything's put in the same way,
Point of,
courthouse would, but if we
Go
did
ahead.
20% to 20% or 30 and 30, that's overall, 60% more of the windows. I mean, it would be a cumulative look. If you get no failures, then I'd say that would be a safe analysis. Different size, different height.
we agree with you, and we can work out the testing protocol, but just as a point of order, right now, we're getting into the weeds on an agenda item that's further down this agenda, and I'd like to focus on the response to the county attorney's statements that were made. And I want to speak a little bit about this, David, if you don't mind.
Yeah, you take it.
But I wish, Ms. Martinez, that you would have gone on a tour with us here recently to the facility to view it, see some of these things. Have you been recently, I'm sorry, I don't know Robert's rules, but are you allowed to respond to a question? Or
It's a workshop.
have you been on a recent tour of the building? Okay, well, I want to get that scheduled immediately because the characterization that you portrayed in front of this court is not representative of what exists in reality. Absolutely. The building got tons of character.
I believe, excuse me, I believe you're just suggesting that she take a
Yes,
site
ma'am.
visit and you can arrange that separately.
Yes, ma'am. And we can arrange
Probably a
that
good
separately.
idea. Thank you.
I've tried to make it a point, and I apologize for Commissioner Dupnick and Commissioner Russo that I was not able to attend your individual tours, but I was on a tour with Commissioner Casterline and Commissioner Cheney. And one of the things that I wanted to ask everybody at the conclusion of their tours is, what is your impressions of the building? You know, don't sugarcoat anything. Let me know what your impressions are of the building. And all of the feedback that we've received thus far has been positive. So I just wanted to get that out there. The question is, and I have read your letter, and on every one of your representative examples, you have a flow chart of sorts that says, you know, is Teal in compliance with the contract? If the answer is no, then go to this. There's a missing step in there, which is the why. And what we're trying to figure out, as well as everybody else in this room, is why and how we got to where we're at. I've been calling.
Just a second. I have an emergency at home. I have to go. I'll do that. If y'all still here later on the session.
Okay. Hopefully everything's okay. There's been a lot of comments in the community about whether we had the adequate experience to build a courthouse, and a lot of questions on if there are contractors that specialize in building courthouses throughout the state of Texas. The answer to that question is no. There's 254 courthouses in the state of Texas, and most of those courthouses are over 100 years old. So the club of contractors that specifically build courthouses does not exist, and if you could find any that have built more than two, that's a pretty small number of contractors. There are architects that have built lots of courthouses. Thanks to an eagle-eyed community member, something was brought to my attention. Back in December of 2018, the folks at PGAL and Architects interviewed for this project to a different commission. I think maybe Commissioner Casterline may have been the only one that was there for that interview.
Commissioner Cheney, but he wasn't at that meeting.
Right.
In December.
One of the topics that came up in the question and answer phase of that meeting, then Councilmember Day asked PJL to tell him about the worst case scenario work problem and how they solved it. Mr. Bonnet, and I'm reading from the minutes, Mr. Bonnet responded it was water intrusion in the Houston area. Mr. Bonnet said PJL stuck by their clients and worked through the solutions. Mr. Bonnet said PJL will stay involved and want their clients to call them whenever there are problems. Mr. Bonnet expressed PJL does not go away until a problem is solved, and to their credit, they have not gone away. However, their partner, Mr. Irsick, said there was a project in Amarillo where the windows were being tested and they had failed for the third time. Mr. Irsick stated that the masonry around the windows had to be reconstructed and that they were all the way through the process, that this is what PGAL does. Mr. Irsick also expressed that they come back 1 year later at no cost to the client and walk through the entire facility. So they've seen this train come down these tracks before. We have not. At the beginning of this project, whenever we were doing value engineering, I made a recommendation to the county commissioners that they remove these windows. Because number one, they're very expensive. Number two, they're not something that you see regularly in this area. They are a very architecturally detailed window that, to Mr. Irsick's credit, contribute to the historical look of the building. However, anything that's unusual has issues, and there are issues that have to be worked through. The difference is whenever we had a failure, we brought down the manufacturer's representative from out of state to come and inspect these windows. I made him stand there and stare at Sharp Glass, who's a subcontractor, completely take apart and reinstall a window to the exact manufacturer specifications. He said, that window's good. I said, you're good? You're good. He started to walk out because they were still putting a little bit of sealant around the edge. I said, nope, I need you to stay here until the last bead of caulk is put on that window, and that same window failed. So we took it upon ourselves. The architects, despite their claims and their interview to this commission, stated that they would be there and work through these problems. They just looked at us and watched us scramble. And so we went out and hired, on our own dime, experts to bring in an extra level of expertise to help us solve this issue. And we have solved the architect's problem. All we want to do is move forward. We want to get done, but we are owed money. We have been delayed, and this is just another delay. Asking about the elevators. It keeps saying that we are substituting an elevator. That is nothing further from the truth. Within their specifications, their basis of design was a Kone elevator. That is correct. But it said, or equal options from TKE, Schindler, Otis. We received 2 quotes, one from TKE, one from Otis. Otis was significantly higher than TKE. I have the quotes in my folder. I can't quote the exact dollar amount. We reached out to Kone and said, why didn't you bid this job? You're the basis of design. Whenever you're the basis of the design, architects often reach out to those folks and say, hey, I've got a project in Rockport. This is what we're doing. Can you provide details for your elevator system, and we'll specify you as the basis of design. Sure, we can do that. Why would they accept that challenge if it was an elevator that they could not sell in this area? I have an email from their district rep saying, we do not service in that area, that's why we did not submit a bid. So we went to the next in line, to TKE, and TKE has a different system. They have different requirements. There's code questions on whether or not the shunt trips and everything else that had to go into this thing were a code requirement or a requirement just for that particular elevator system. But we're only able to do what we have the option to do. If you specify something, a Mars rock, and we don't have a lunar rover to go to Mars to get it, we cannot provide that for you. So we're here to provide solutions. And right now, the way the toxicity within the project team, we are basically being ganged up on because it's a deflection, in my opinion, a deflection of responsibility. And so it's a lot easier to beat up on Teal because y'all hold more of our money than other guilty parties. And I'm not here to tell you, and I've said it in public before, that we are 100% clean on this. We have made mistakes. But we need the opportunity, instead of a forum like this, I wish our tables were up against yours so that we could have a real heart-to-heart conversation, include the design team, include the folks from Broadus, include everybody, and work this through. We're building the high school. We're building Fulton Learning Center. We've got a design team that is out there every single day, or every single week, watching us, watching our in-place mock-ups, making sure that every detail is correct before we proceed with work. That happened on this job too. That's how we got to where we're at with the exterior masonry. They asked to do a full in-place mock-up on the northeast corner of the building. We put it all up. Architects just came out, observed it, says it looks good, proceed. We start moving down the building. They come for another inspection. There's slivers of brick underneath those windows. We show them their elevations. There's slivers of brick underneath your windows on these elevations. Oh, that's diagrammatical in nature. Refer to this. Adjust coursing. Adjust coursing, what does that mean? Well, you need to add a brick or subtract a brick. That's the only way you can adjust coursing. Adding a brick, subtracting a brick. When you have a water line of brick and you have to work magic, and I actually applaud TM Workzone for doing this in an amazing way, and how they adjusted their coursing as we were directed by the design team to eliminate slivers of brick under the window. But what that translated to in reality was a 2-inch differential, 2 to 3 inch differential that is spread out over 180 feet. 180 feet? Over 100 feet. I'm just going to call it over 100 feet over the length of the building. That I've stood out there with many of you, and even with me pointing it out, you cannot visually see it because it's 40 feet in the air. And so we're being asked, because that is non-conforming work, to tear down the entire exterior of that building and start over on our dime when we were only doing what we were directed to do by the design team.
Did they write a memo? Is it in writing?
Absolutely. Absolutely. Adjust coursing. So these are the things that we want to be able to communicate to you. These are the things that we have wanted to communicate with you since the beginning of this project. But we have been, in my opinion, intentionally excluded from the conversation when it comes to these issues, because it is not favorable to a design team and an owner's rep who would much rather deflect onto Teal Construction. That's all I have.
Hey, could I ask a question?
Yeah, absolutely.
Since we're talking about the brick and everything, when I was reading through all this stuff yesterday, I thought of something that I remember there being an issue also with where the ethos connects to the brick.
So,
It was designed to go one way, and maybe it's not that, like, it was designed either. I think it was supposed to lap over, but it ended up sitting on top. Is that?
I don't know about that in particular. On the agenda, there's, I think, 4 items. It talks about brick, ethos, tile, and wood. And those are all relative to the same issue, right? Because if you start off at the bottom at a certain level, you move up so far, and then you're instructed to adjust coursing, and then you have to bump something up slightly, 2 to 3 inches on one side. That translates all the way to the top, right?
I
So
understand that.
the ethos has to sit level with the top of the cast stone at the top of the brick. And then that also has to be level on the next course up before you get to the tile, because we have an intricate pattern cut into the ethos where you have the little bitty 1-inch tiles doing the X's on the corners. And that has to be laid out to where that dimension has to be held.
I understand all
Mhm.
that. My thought was that in the past, there was a deal that the ethos was actually supposed to lap over, be on the outside of the brick where water, rain, or whatever wouldn't go down in the brick. I might be wrong on that, I don't know, but
If that is an issue, it hadn't been brought to our attention. And you might not be communicating it exactly, and maybe it's something else,
I
but
might not be, but it's something where they tie together that, my understanding, it's set on top of the bricks instead of being on the outside edge of the brick.
I can find that very easily. I do have that.
And it might be in one of the pictures that Elle gave me or something, I don't know.
Elle, do you have information about this?
Not where they're talking about the ethos, there was concern, about the shelf trees at the bottom of the building. But I don't remember anything about.
No, what I'm thinking was on, and I might be confusing with something else, but I just wanted to ask them.
I kind of do remember a problem with the ethos, like there's supposed to be back a rod somewhere and you couldn't put it on. Well, I think we'll get to it. I think it's in the agenda.
any other questions?
Thank you, Mike.
No, I did have a question for Mr. Payton. Mr. Payton? You had mentioned there's some problems with the contract, and you reached out to the county attorney's office for lunch. Did you try to just schedule a meeting instead of lunch?
Well, yes, I was trying to schedule a meeting, but in a friendly way.
Oh.
She wasn't objecting to the lunch. She was objecting to meeting to discuss the contract.
Okay,
I've got an email exchange on that I can dig up if you'd like to see it.
I just wanted to make that clear. All right, appreciate
I'd like
it.
to see that, thank you.
I'll find it for you.
All right, so we addressed. Oh, yes, we're going to take a 10-minute break.
for you. And he conducted a walkthrough on February the 14th, just last week. And these are the remaining items that were identified to get the project complete. And within the last week, Teal might have progressed on some of these items. I have not confirmed that yet. But as they did state, the end is in sight. And so there really is an opportunity here to complete the project. So I'll go down the list. Judge, I think you have the list as well. I'll make sure and provide copies of this to anyone who needs. Item number 1 is to complete the paving and grading at the east stairs and remove spoils and debris. 2, remove unused stone and other materials from the site. 3, install brick pavers at various locations. 4 is to stain, soffit, and lift. There's a lift requirement in there. Number 5 is to install the illuminated Aransas County Courthouse signage above the arched entryway. 6 is to remove or reinstall louvers at the roof inner wall because there was an issue with the roofing membrane not back wrapped properly and it was leaking some water. So that needs some corrective measures. Number 7 is to install blinds and window coverings. Number 8 is to complete overhead door installation where there's some structural steel exposed. Number 9 is to install aluminum handrails at various locations. Number 10 is the elevator is not yet operational. It is complete, but it needs to be inspected and certified. Number 11 is electrical device trim out. There are some cover plates that are missing. Number 12 is to complete the install of the storefront and water test per specs. That's AAMA 501.2 at 2 locations. Number 13 is to repair.
Can I ask a question?
Yes.
AAMA?
That is a testing standard.
Okay, thank you.
The architectural testing standard. AAMA 501.2 is the architectural testing standard for windows. Window repair per the architect of record requirements. As they had mentioned, there are some retest requirements at various locations. Number 14 is to reinstall the gypboard, tape, float, sand, prime, paint, and install stools around all areas after successful testing. So that's around the windows after they've completed the testing, then they should be completing the finish work on the walls. Number 15 is just a general building cleaning, which is required. Number 16 is training of the systems to the courthouse staff, windstorm certification, and the remaining closeout documentation. Number 17 is final installation of courtroom audio visual courtroom equipment. And that is the list of items that we have that will take this building to fully operational.
You said fully operational. The courtrooms are not operational, and which I know you don't, that's, I think someone said scope, maybe, but we don't have courtrooms, and also the jail, the jail section for prisoners, that's not operational either, right?
Yes, sir. This was considered base scope of work. This is base scope of work. The other items we have, and I'm sure the county attorney wrote it in the letter that we reviewed, but the other items were removed from the scope and need to be added back in the scope in terms of jail doors, millwork in the courtroom.
But the courthouse cannot be fully operational for what its intended purposes is without the courtroom and the jails.
Yes, sir. Yes, sir. This is base scope of work.
Base scope.
Yes, sir.
So in item number 13, is he or y'all are y'all recommending that we do the thing that the city's doing with Teal about doing the fix and test in 21? Is that what it reads like to me?
Yes, that's going to be an architect of record needs to make that decision, and we'll monitor that and make sure that it's properly executed. But that'll be between the county and the architect of record to make that decision.
When you say that, I have a question.
Yes.
If Teal is proposing a solution that has worked to some extent anyway with the city hall windows, then you're saying the architect of record, which would be PGAL, would have to agree that, okay, let's try that test and see if it works?
Yes. Yes, that's what I'm saying. Is if the architect of record deems that solution is a viable solution with the window set, then that is something that they can make the determination. The county can accept that and make that directive happen. Otherwise, right now, the windows, at least I haven't seen the documentation, aren't warrantable or functional until they get that completed.
And if the architect of record doesn't give the approval, can the county, as the owner of the building, go ahead and say, we want to try that option?
Yes, ma'am, they can.
All right, thank you.
Yes, ma'am, they can. It just has to be documented and then proceed forward. And, if there's a ability to get a fully functional window and it's warranted, that would be the big thing you want to do.
Thank you.
Yes, ma'am. Any other questions?
Commissioner Russo, I believe maybe you can ask the architect,
All right,
how
but
long
I did get
it
an
might
answer.
take for him to come to a decision, since he's here.
Thank you.
Thank you.
Thank you. I do want to, Paul, would you like to speak about that issue, number 13? And I do want to let the court know, so Paul called me, when'd you call me, Friday?
Yeah.
This past Friday, which
Yes.
a week ago today.
Yeah.
And told me that you came to an agreement with the city, with Teal about how to proceed on the city with the fixing of their, non-conforming non-conforming install.
Yes. So,
Yeah, it hasn't been presented to the court, and that's why, according
Understood.
to Mr. Payton's letter, when he says Teal has yet to receive direction from the county on this issue as it relates to the courthouse, because the city has approved it, this is continuing to delay resolution of the window issues. We haven't formally even been presented this, so if you could
understood.
present it.
Yeah. Well, in other meetings, there were some discussions with the county about going a different direction. I have not. And I knew this meeting was coming up, so I thought that this would be a good discussion for this meeting. We did write a letter to Teal after discussing the issue with the city, with Architectus, with our own envelope consultant, that the suggested fix by David Nicastro that Teal implemented and tested and was successful, that would be a reasonable solution. My concerns and the design team's concerns were that it was a warrantable condition, that the sealant installation would, at least meet the warranties that are in the specs. And again, as I mentioned, we consulted with our own design team envelope consultant and came up with some recommendations for Teal and the city and some steps to follow to make the fix on a certain number of windows, 20% of the windows, test those windows, and if those windows pass, then we and the city decided we'd feel comfortable moving forward with that fix, rather than potentially taking out all the windows, reinstalling them, having to do other remedial work that would make things more difficult, more costly, more time consuming. So,
And it seems like the suggestion Teal made to wait, let them do the 20 for the city, if it worked, do the same thing on ours.
yeah.
Seems like a reasonable.
We decided that the fix that was being suggested, and the fact that they tested it and it passed the testing that we'd been doing, that was a reasonable solution. And I think we would recommend that the county do that too.
All right, thank you for that, because
Okay.
I'm looking at a copy of the letter
Uh-huh.
that we received, maybe in our last workshop, excuse me, dated January 31st, that Justin McComb had sent to the court, just talking about the fact that they had hired David Nicastro to come and take a look, and going through a timeline during the week of December 10th, the remedial work was completed, tested on December 17th, retested by a different, inspector
Right.
on the 30th,
Mhm.
and they were waiting for some sort of feedback from the owner slash design team. So a month had already transpired, and now we are sitting here February 21st, so 3 more weeks beyond
Okay.
this letter. So that's about 7 weeks or so. And now we're hearing that there may be a response that we could look at.
Yeah.
Can we get something more official
Yes, you
for
can.
the court to consider and act
Definitely.
on?
And we were having discussions with, at ROAC meetings and separate meetings with the county and some of the other consultants that you've hired to assist with the project about these issues. And there was some discussion that the county wanted to go a different direction than what we were doing for the city. So I wanted to have that discussion here. I think it's reasonable to do the same thing for the county courthouse building that we're doing for the city
That would
city
be
hall.
good if you could provide us with
Yes,
an official
I will do that.
response. Thank you.
Do you think, the suggestion was made that if being the windows were both installed in the same method, and the city's gonna have 20 windows tested, and if you're accepting of that, is it really practical or advised for us to have our own windows tested when they're all being done the same way?
I think I would leave that up to you all to decide whether you, I mean, they're the same manufacturer windows with the same details and the same, really all the same materials.
Well, at the same time, it's a separate building.
I
It's a
understand
separate
that,
building and a separate contract and a separate client.
I understand that, but like if you build 100,000 cars, they have their prototypes they test out, and you're accepting it, and I'm just asking if it's really a necessary, I'm just trying to find out if it's a necessary fee, that we need to take care of, or expense.
I wouldn't agree that we should, I don't think we should not test
Do you think we should?
windows. Oh, yeah.
Okay.
I would prefer they be tested so that my records are protected in a room that shouldn't have windows to begin with.
Well, like I said, it's just a question I'd like to get the feeling, because it's, like I said, it's the same windows, basically the same process, and I was looking at cost.
But I think maybe we don't need 20, we can decide that later, but
Yeah,
I think we
I'll
definitely
provide a
should.
similar recommendation to you that I did to the city. And then, I guess we can have some separate discussions or discuss further whether you want to actually test the windows.
20% or 10%, we'll have, yeah.
Yeah, we can
Online.
decide on a number. The 20% was the recommendation of our waterproofing consultant that we've been using. So, anyway,
Thank you.
all right, thank you.
Were there any more questions on the broadest summary that came out of?
Do you have any more questions on what Broadus presented? No? All right.
I would just ask if Broadus could make a copy of this for the county clerk, probably the county attorney, and then maybe give it to Teal so they can take a look at it and not necessarily respond right this minute, but, okay, that would be good.
Judge, point of order, Mr. McComb, there's several things that Mr. Monreal, cited in his report that have already been corrected and completed.
And he said that at the beginning, that some items may have been completed already.
So if you'd like Justin to scrub that list and go through it, let you know everything that has been completed.
That would be great.
Scratch
Yeah.
off yours.
That'd be good. I do have a question about the windows, just to be clear, because it wasn't answered earlier.
I'll come to the mic so that people listening at home, I know I've gotten several text messages from folks that say they can't hear.
Yeah,
Okay.
they
So-
tried to do something during
Trying to
break,
fix
so
that.
hopefully
Okay,
it's
good.
working.
So, okay, so the architects working with the city, and they found the solution that the city agrees. Have you started doing work to the windows to retrofit them, or whatever you're gonna do? Have you started the fix yet?
That process hasn't started.
Other than the 2 windows that we have done on your building and 2 windows that we've done on the city hall that we did to test for our proof of concept,
Right.
Those are the only ones that have been tested.
Okay, but since y'all agreed to this testing 20%, the agree. Okay, so y'all haven't started that work yet.
We haven't,
No, we haven't actually agreed.
We haven't agreed to that.
The method of doing the fix, but not all the terms that were on the letter.
Okay. I was just.
What our concerns is, Judge and Commissioners, is, okay, so we're gonna select 20% of the windows. Let's call the building has 100 windows, so it's 20 windows, right? Mm-hmm. So what's being asked of us, and I wanna make sure that y'all understand this, is that they have prescribed those 20 windows. We're gonna go in there, we're going to do what's called the fix. I don't like calling it a fix, it's a solution is what it is.
Okay.
A fix makes it sound like we've done something bad and this is how we're going to Band-Aid it, right? That's not what's going on here. Now, once those 20% of the windows are done on our side, then we got to bring in the testing lab. And I want everybody in this room to understand right now, I know that I've said it in the past, but just so that you remember, Blue Quality Services, which is the original testing lab that has tested this all the way through this process, is now out of business. So they're no longer available to retain to come and test these windows. So it's going to be a different lab. But I just wanted you to know that so that you don't think that we're being accused of switching labs or doing any kind of witchcraft on this thing. So once those windows are all tested, and mind you, we can get about 4 windows done in a day.
Yeah, testing 45, yeah.
Because once they set up, they put the spray rig, they run the 15-minute test, break everything down, move to the next window. It takes about a full, a day for 4 windows. So 20 windows, that's 5 consecutive days of testing. Their daily rate is
4,500.
Blue Quality Services daily rate was 4,500. We haven't, and I say we, it's not our responsibility to go and find this testing lab. The way the specification is written is the testing lab is selected by the glass contractor and approved by the architect. So once the glass contractor has found a testing lab that the architect approves to, bring them out. There's the cost involved with testing this amount of windows, right? So let's say they're $5,000 a day. 5 times 5 is $25,000, right? Part of the disagreement and part of why we don't have a agreement yet is, okay, you want us to test these 20 windows, even though the original spec says you're testing far fewer, but who's going to be responsible for all of that cost? Now, if we test all 20 of those windows and all 20 of those windows fail, obviously we're responsible for that retest, right? But if all those windows pass, and we've already come to the court and said, hey, we've already passed these windows with our own independent testing that was proven twice with 2 different firms, and our concept continues to pass beyond that, I don't think that it's reasonable for us to be able to ask, and I'm not saying you asking Teal, but it's us asking our glass subcontractor to absorb the cost for that additional testing if they tested something that passed, right? So that's where kind of that hang up is a little bit on our side with that testing regimen. And then beyond that, once we have tested all those windows, that's when they say, okay, you're free to go and fix the rest of the windows. So it's an additional time suck beyond, going and doing the original testing regimen that was in the original specifications.
Okay. I just want to be clear because people have come to me saying, hey, the city's got their stuff together. They got their window solution. What are y'all doing? Y'all are just sitting on your hands, but y'all haven't even started the work yet. And I just want to clear that up.
That's correct.
All right. Appreciate it.
I believe, and I was watching the city manager's head. When she came up here earlier, she said it was not officially agreed to yet. They've talked about it in principle, but a formal decision hasn't been made. Is that correct?
That's
correct. Okay.
Yeah.
So they can't start the work until
Also,
city council gives its approval.
It's pretty important to note, and it's something that we have to decide on our end, because part of what Mr. Burnett wrote in his letter basically absolves him from design liability for this. If we move forward with this, he says, you'll have to do this, 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 and this, but you're also going to have to accept, liability for these windows should they fail in the future or something like that. So
And when you refer to his letter, is that a letter he wrote to the city?
To the city, correct.
Okay, so we have not seen that.
I don't know what you received or not.
I have not seen that.
We
letter.
haven't
Okay.
gotten a letter yet.
All right.
But for
Thank
full
you for that
clarity,
clarification.
the size, the type, the design of the windows on both buildings are identical, so whatever letter was presented to the city should be equal to whatever is presented to
Most
the
likely.
court. Thank you.
It just hasn't yet.
Justin, McCollum?
I'll turn it over to Justin to go through.
All right, we'll just run through this list here that Mr. Monreal brought up. His item 1, complete paving and grading at East Stairs. That work for us is complete. As you know, there's 3 projects on that same block with DLF working in the middle between us and the city on the community building. And they've got the actual piece that connects the 2 buildings with their planar walls. So the debris and the work that's going on out front is part of their contract and not ours. It does look like it intertwines, but that is their work. Item 2, remove unused stone and other materials from the site. Again, that's the work that DLF has, that wall that they're putting in. It gets stone caps and stone veneers and brick and et cetera on it. So all that material that is currently right at the street level or just across the street in the parking lot is for the project there in the middle, not for our project. Install of brick pavers in various locations, item 3. All of those pavers are complete. They're all in. They've been set. They're actually setting or filling in the sand in between the pavers today, but all the pavers are set in each one of those depressioned areas. Stained soffit requires a lift. So again, all the pavers are in. We can now get up there with ladders. They're going to do that. As you know, it's been exceptionally cold this week, and so in order to get that stuff to bond and stick and set right, we're letting the temperatures try to get at least back into the 50s and 60s before we get that. But that's on the books for sure. Item 5, install the county courthouse sign. I think those of you who came and took some tours this week were able to see that. That sign's up. If you've been by in the evenings, it's also illuminated, so that work is complete. Remove and reinstall louvers at roof inner wall. That's not on our books right now. The roofing manufacturer had come by, I believe it was 2 weeks ago, looked at all the details at roof curves, roof fields, parapet walls, the louver tie-ins, how all that was put together. He has no problem, and he has issued his warranty letter for that system. So the idea of trying to pull all that stuff out, interrupt his system, and reinstall it is not currently on.
So it's not leaking water?
I haven't seen it leaking water now. The
So,
original.
Excuse me then, are you saying that work won't be done? The remove and reinstallation of the louvers will not be done?
Correct. Those are tied in, and that's inside of the report from the roofing manufacturer, and that letter's included, or will be included in the closeout documents, but we can send it over to you now if you'd like. Item 7, install blinds and window coverings. That's correct. That's not complete. That can't be done until the windows are done, drywall and all that, so that'll be outstanding. Complete overhead door installation. He's got structural steel exposed here. There was the framing for the opening was steel. That's now been encapsulated in the pre-finished trim that matches the door and the opening, and that's completed. There are brackets that the canopy attaches to. Again, that's the material that's got to be over 30 degrees when they go to paint it, and so they're working on that just as soon as conditions warm up. But that's the only item that's out. Install aluminum handrails. That's correct. Our install and delivery date for that is March the 10th, if y'all want to put that down. Those are waiting for all the stonework, primarily at the entrances where we're tying in with DLF to be completed so they can get their final measurements on those openings, but those will be installed on March the 10th. That'll be the ramps and steps at each location. Elevator not operational. As he said, it's complete, just waiting on inspection. There's some guys in the building right now double checking the programming, making sure everything is recalling to the correct floors and certain devices, smoke devices, heat detectors, all that, just kind of double and triple checking it all again. We're just waiting on the inspector to come back out.
So the
and-
guys in the building are like electricians or some of your
it's-
folks?
It's the guys who are doing the access control, the fire alarms, that system, just to make sure that everything is tracking like it's supposed to.
So the inspection is
Just
scheduled?
waiting. Yes, I don't have a date. That comes through TKE, and TKE has to go through the state to do that. But yes, that's on the books. Electrical device trim out, some cover plates missing. I don't know where there's one missing. If there is, I haven't seen it. But again, this was from a week or so ago, so that item, in my opinion, is complete. Complete install of storefront water testing. That also is correct that it has not been done. That's also tied into the windows and how we agree to fix the trim and the brick mold around it. It's got the same condition. So once we have the okay and the green light to proceed on the fixed windows, that same fix will carry over to the storefront. All that will be installed, completed, and then we can water test it. Let's see here. Reinstalled jip board, tape float, etc. That's again outstanding. We're waiting on the windows so that we can get that finished. Building cleaning, we're 4 or 5 times into that. Again, we still got to go in there and cut drywall, sand drywall, paint, do everything we got to do for the windows. There's going to be a cleaning after all that's done. But for those of you who walked through the building in the last week, y'all were able to see that the building is picked up. It is clean. It's a usable building in terms of cleanliness. Training of systems. Those trainings have occurred with some lighting and mechanical work. We've obviously got TAB reports and fire alarm reports and that kind of thing to give back. The AV testing we can't do yet just because the whole system's not set up. We need Colin to finish what he's got to do. He's obviously hesitant to move in until we get the windows addressed, so that's kind of just one big item we're working through.
Hold on 1 second, Justin. So number 16, training of systems to courthouse staff, windstorm certification, all closeout documents. So Al, Renee, have your staff members been trained as they need to be? Do you want to come to the mic, please?
So yes, sorry, El Morales, Aransas County. Once all the systems are up and running, and again, we're waiting, we kind of are in a little hold period because of the windows. Colin cannot get all of his server equipment in there. Once all of the equipment is in, then they'll schedule for Renee's staff to come in and get the proper training so that they know how to use all of the lighting controls, how to use all the audio visual with Colin's IT people.
So it's going to be delayed until the windows are done?
Correct.
Okay, thank you.
I can say one thing. Hello, Colin Jackson, Aransas County. I can say one thing on the access control and the camera systems that are in the building. About a week or so ago, my team got in there and we installed a couple of network switches so that we can, now that the fiber is in place, so we did install a couple network switches so we can start moving forward on the access control while everything else is still being worked out, so that's not held up anymore. So that testing can get underway without our equipment having to be in the building.
Yeah. Thank you.
Good, thank you.
17, final install of courtroom AV. Again, what we can install without final furniture and desks and all that has been installed, and so we're good there. And that should address all 17 of his items there. Is there any? Good.
Question, Judge. If so the courtroom work has been taken out of your scope?
That's correct.
So you can't
upstairs. Yeah, the two upstairs, district court and county court, correct.
Both courtrooms have been taken out of your scope of work. So
Yes, sir.
can the audio visual work be done on your portion, or that wait till both courtrooms are complete?
Not right now. It can't be now. Once the work that has to go on inside of those courtrooms involves taking out all the millwork, all the benches in the front, and that's got all data in it, power in it, etc. So until it's all put back together and tied back in, there's not there's not any point or any way to get it checked.
Any other questions?
Hey, Bill, and maybe this is a wrong item, but the judges' benches and stuff, did y'all ask for an update on the bid that y'all had got from the people that does it? I know that was some time ago.
I had a conversation with them about it. Pricing wise, no, we haven't. We're still working off of some of the old sketches. We don't have a finalized detailed plan to really, put a fine tooth to it. There's in the original pricing we turned in, there was a lot of guesstimates, if you will. We think it'll be this based on a sketch. We think it'll be this based on a sketch, but we don't have a real plan on it yet. But if it's going to be added back into our contract, that's up to you guys, I guess. Then we're obviously going to make sure that we've got a full set of detailed plans so that we can get the best price and send it back to you.
When I went on the tour the other day, we also went through the city hall.
Yes, sir.
And their courtroom stuff, if I understood right, that they met the requirements that are
yes, sir.
in the laws or whatever. So who did PGL, did they do the design on that one? Or?
Correct, yeah. PJL did the design work for both of the buildings.
I asked.
So have they?
All of it. They're the architect of the project. They designed all of it.
I asked that question yesterday when I was doing the review. That's the first time I went through City Hall. And I asked Kimberly Henry, who's the assistant to the city manager, if their courtroom was going to be usable. And she said yes, because they put in 45-degree corners.
Well, that's what my question is, did Paul and them, did PGL, did y'all design that for them?
Why the difference? Why does the city's courtroom work and the county's courtrooms
They
do
found out ours didn't work and then they could change it.
No, that's not. Both projects were designed at the same time. We did the design work along with Architectus and the rest of the design team for both. We did issue a proposal request with final drawings for the changes that we were asked to make to the county courthouse millwork. So Teal does, as far as I know, have all the drawings from us that you need to be able to price the work. So the original question was why
You designed theirs after you found out that ours wasn't right?
No, that was the city hall, the council chamber, and the court at City Hall was designed like that from the start, from the when the bid documents were issued. So
Why?
They don't seem to have an issue with the layout.
Because they have a 45-degree angle
Okay.
at the different edges so that there is a line of sight.
Okay.
Whereas we have 90-degree angles, and it makes a very big difference.
Okay, I may need to go and review the plans and look at the specifics with you. The rooms are not exactly the same size or configuration, so the design of each one is a little bit different, but.
I would like to know why theirs was designed with 45-degree angles and ours was
Okay,
not.
I can get back to you on that.
That would be good.
All right.
Thank you.
But you said Teal, you said Teal should have everything they need to.
I believe so, yeah, we issued a proposal request with all of the requested changes to the courtroom millwork on the courthouse project. So signed and sealed drawings. There is typically a process where you go through, creation of shop drawings, and we did that on the millwork for this particular project, and those all went through and were approved by everybody the first time, and then in the final, I guess when people started going in and walking through and sitting down in chairs, it was determined that they needed some changes to it.
Maybe I'm confused, because I thought Teal was not gonna be doing that work for the courtrooms.
We took it out.
It is technically rework, which
Right.
is new work, which should be bid out if it's more than $50,000.
Well, I think, yeah, it's one of the items on the agenda, toward the end of the
Yeah.
agenda, if I saw correctly, with some of the detention jail door work, the courtroom mill work, and there was another item on there that
The
was.
fire suppression.
Fire suppression, yes, for the clerks.
Thank you, Paul.
Okay, bye.
Thank you, Justin.
May I address something that the county attorney just said we disagree on?
You got 2 minutes.
I don't need that one. The rework can be done without having to rebid it. It's literally rework. And under chapter 262 of the local government code, you can put all the things you descope from Teal back in. There's a 25% of the whole contract threshold thing. It's not the $50,000 thing that she's talking about, which would be new work. So we just disagree. You have the authority to do it without having to rebid that stuff.
Thank you. All right.
Judge Garland.
Yes, ma'am.
To be clear, Teal built the millwork in the courtrooms. At one time, their stance has been, they built it according to specifications. Under that circumstance, the architect should say yes or no, it's built to their, to the specifications. And then if there is a problem with the millwork, like, for example, it doesn't meet the requirements of the Sixth Amendment, that's a different issue. And we are there in that different issue. So if Teal built it the first time, that was in their scope of work. Teal has asserted that they built it correctly the first time. That's why I'm classifying it as rework. And that's why I believe it's subject to the regular rules of procurement, because there are things on the horizon that are known as unsuccessful bidder suits. So if we did not put out all the work the first time in the RFP, and we added work here and there, for the person who did not get the job, they can sue the county saying, well, you didn't let me bid on that. I could have had a different bid altogether. So those are just factors in the background, but because it was not, Teal did what was in their original scope, and because there is a separate problem with it, hypothetically not dealing with Teal's quality of work, that's what I believe makes it rework, and we have to rebid it.
We can look into that
Yeah,
at some
well,
other time.
Thank you. Thank you. All right, we're going to correction. We're going to move on to B. 2B, correction of non-conforming and or defective work. We've talked about the facade EFIS. Mr. Montreal, would you like to hit on the EFIS, or do y'all want to go through this non-conforming work?
I thought we'd sort of done that with the information from Brock.
I feel that you've hit all of these already.
I think so.
If there's anything that the commissioners would like to hear more about, I think that this is the forum to ask, but if you feel you've heard enough,
I think we've heard it all. Do y'all have any questions on the non-conforming work? Okay. We're going to go to MEP testing and commissioning. I guess that's on Teal. Would you like to present? I guess where y'all at on MEP testing?
So it's kind of like what we said earlier. We're able to test what we can right now, test and balance the mechanical systems, the lighting controls, all that stuff is good. The commissioning of the project is not on our contract. DBR is actually the commissioning agent that's going to come in and do the full commissioning and certifying of the building. But the systems being in place and being complete is done.
Who's the contract between DBR and who? The county?
Through the architect.
Oh, okay. As far as the MEPs, it's all good to go. Air conditioning's all done, electric's all done.
Correct.
Plumbing's all done.
Yes, sir.
And it's going to pass the first time.
It should.
All right. Cool.
It matches the drawing, so it should. It all works.
Thank you.
So has a punch list
We're getting, that's the next one. That's the next one. All right, 2D, report on substantial completion and the punch-out process. Mike. Yeah, kind of.
Judge Mike Monreal, really, that was in there to say that that is a remaining item. So we've started punch walks, identified some things are getting fixed, we just need to complete them, but obviously the windows need to be corrected, and then we'll complete the punch. So it is an item of work remaining that the county needs to, we'll work with the county and make sure that everything is identified that needs to be fixed at the very end.
So a couple of months ago, we had L and we had the architect team, the design team go in there and start punching out the building. Did we finish punching it out, or?
Well, we considered that a pre-punch.
Okay.
So it was just to get, whatever could be punched, we wanted to advance as much as we can so we're not wasting time.
Did y'all make a list?
We do have a list.
Does Teal have that list?
I believe they do, but I'd have to confirm with Mark.
Justin, do you have that list?
So, yeah, we got the list that was created months ago. And we picked 3 or 4 different rooms throughout the building, an office, a restroom, a break room, work room, and maybe one other room. And got those rooms addressed with all the comments that were on the punch list that we've been given, or call it the punch list. Walked back through the building with Broadus and with Elle and kind of everybody on the team, and looked at it and said, okay, if every room when we get out of here looks like this, you've addressed our items. We said, okay, great, let's go finish the windows and we'll get out here. And 7, 8, 9 months later, we're trying to get the windows buttoned up so that we can do those punch list items in each one of the rooms. But for the rooms that are not affected by the windows, those rooms have been addressed and taken care of. We just can't finish the rest of them until we get out of the window issue.
Okay, so on that punch list you had that don't have windows in it, you've addressed all the problems.
Those rooms are good, yeah. Again, your courtrooms are not on there because that stuff is not on our work. The detention areas, those went on pause. Any of the rooms on the exterior of the building, so it's the clusters of offices that are on the interior of the buildings. Those items have been addressed.
Okay.
Is it, Elle, would you agree with that?
I would agree with that.
Okay, thank you.
For the people who can't hear, Elle agrees.
She's coming.
Oh, she's coming.
So I can't really remember, but I feel like we did that in November when PGAL and myself and Broadus, Mark with Broadus, went and did the walkthrough of the building. And like Justin said, we stopped with the exterior because of the windows. So all those exterior building or rooms still need to be done. But they did come back through and they addressed all the restrooms with the tile issues that we had, those kind of things. They've all taken care of all those.
Okay, thank you. 2E, removed work from, we're going to discuss about the removed work from the scope of work, i.e. the fire suppression work in the county and district clerk's office, jail commission standards, and the courtroom millwork revisions. Were y'all going to do pricing? Were y'all going to get some pricing before this meeting on those items?
Apologies, Judge. As you and I discussed yesterday, we received we didn't receive notification, but we realized that the agenda and the agenda packets for this meeting were posted on the county website. They weren't sent directly to us. So we had to, in very short order, go through this agenda. You and I had a discussion yesterday about how this was going to go down. There wasn't a very good degree of certainty between either of us on how this was going to unfold. So no, it wasn't our understanding that we were to have any kind of pricing prepared for this meeting. Last night, we did put together at Commissioner Russo's request an accounting of kind of where we're at today with our claims that obviously build with every day that goes by. So we provided her with that. But as far as any,
I've not received it.
We didn't get that sent out. It got updated late, and we missed the 5 o'clock
Oh,
We've got
okay.
copies to give.
Apologies, we do have it for you though. So as far as any pricing of any rework, there was preliminary discussions with the design team. They did provide us some sketches and stuff for the millwork. But there was some talks after that, Heaven kind of filled me in, pardon me, hold on.
I thought after our last special meeting that it was agreed that we're gonna discuss this and y'all are gonna give us some numbers so that we can make a decision here on.
Let me ask my team a question. We did supply them with some preliminary pricing, correct?
There's been preliminary pricing in the past. We've kind of updated it just based on the amount of time from the original until now. But we do not have full buy-in from subcontractors associated with it. But I do have numbers that are probably plus or minus pretty close of what it would be.
But there was additional conversations that happened after we had submitted some of those numbers for consideration about, like you said, possibly 45ing the judge's bench to allow better sight lines. And so there was talks beyond us, and then all of a sudden it was brought to our attention that we would not be doing that work. But I did want to address something that Ms. Martinez mentioned. Under your definition of rework, jail standards, attic insulation, those were all north of $50,000. And those were all, under your definition of rework, technically rework. So I don't agree with your definition of the rework, and that it needing to follow, state procedures, because, it's basically like a change order. It happens on any project. But if you're concerned about lawsuits, there's been lots of
Let's stay
rework.
focused on what we're here talking about.
Yes, sir.
But I think that we need to sort that question out, but it's not fair for them to give us a price to do it if we're gonna put it out for bids where everybody's can see it.
Yeah. Well, if the price was extravagant, well then maybe we would be more inclined to put it out for bid.
I don't know.
That I can't force somebody to provide a service or a good to the county that they are not willing to do, right? Where you can only do so much as a general contractor. We can confirm material pricing and things of that nature, but as far as what somebody's willing to do something for is somebody else's decision other than the general contractor. So I know there's been several instances in this process where we've submitted a price to the county for a requested item, and that's been scrubbed by the design team and by Broadus, and either the design team or Broadus or both have disagreed with the cost that was submitted. But I can't put a gun to somebody's head and say, do this for that price, right? So this type of work, this millwork project, we could bid it to several different millwork firms. We do have concerns about warranties that are in place because you have millwork that's interacting with adjacent millwork that is not being ripped out and redone. I think that those warranty, the exposure from that warranty issue is probably minimal, but it is something that we'll need to let you guys know just so that you're aware. I'm not saying that if, all the laminate starts peeling off the walls, then their warranty's not going to be good because we came and put in a little bit of millwork at the judge's bench. But there could be a situation where that would become a concern with the millwork warranty.
There's a difference between rework and a change order, the amount of dollars, because some of the change orders we've done have basically been rework.
Yeah.
And so I'm trying to understand.
They've only been reworked if we accept that definition.
That's what I was trying to.
If Mr. Payne made a statement about state law, and if it's in excess of 25% of the original contract, then you have an obligation to bid that out, correct, David?
No, there's a prohibition on exceeding
25%.
Right, we've addressed that several times with our contracts on the road work that we've done.
That's what makes sure everybody's on the same page. The section I'm looking at is 262031B, which sets that 25% of the prime contract as a threshold. If you're under that, change orders are fine.
Okay.
So
you're not ready to present a number for item E? That's what this was about. This whole meeting was about, for you to come and give us numbers and.
Item B?
No, item E.
Item E.
Remove work from the scope of work. Talk about the removed work.
No, actually, I wanted to hear what it was gonna take to finish this job.
Correct.
Yeah.
So
You
this-
wanted the sum
this is
total of all
part
the
of it.
claims.
That's part of it, yeah.
A lot of what we've heard already has answered several questions.
In a suggestion that I made, I can't remember where I made it, with regards to the fire suppression work, because we haven't been given any direction of what type of non-wet system you're looking for. And so there's multiple different options. One thing that I suggested is ask us, especially if cost is a concern, it's probably a lot easier than Paul sending us a directive on a system and we going out and pricing that system and then you guys saying it's too much. It might be easier and more efficient if we went to our fire protection contractor and say, hey, how many ways are there to skin this cat and can you give us a price for each? And then we can confirm that with other contractors and try to do it that way to be more efficient at this, because a lot of the delays that we've had with approvals of these change requests and things like that have been price, reprice, reprice, reprice. And Judge, as you know, there is what I like to call estimate fatigue. And whenever we go back to that same contractor and say, it's too high, go back, change this, this, and this, reprice, reprice, reprice. Everybody says, oh, contractors make all of their money off of change orders. The amount of time that it takes to reprice and reprice and reprice, and then inevitably get to a point where it's like, no, we're not going to do it. We'll take it out of your scope. We'll do it under a separate contract later on. It's, there's a lot of fatigue involved. But one of the things that I had a goal whenever I initially conceived of this meeting back in April of last year was coming up with a list of kind of a slate of items that you guys could approve, right, with regards to settling outstanding claims. I don't think that that's going to happen at this meeting. I don't have any expectation of that at this point.
We can't take any action at this meeting.
Right. But preparing a slate for the next Commissioners Court meeting that everybody agreed upon is this is how we're moving forward. I just don't know that.
Do you have that with you?
I provided it. I mean, we've got the list of dollars.
I can go through the dollars if you want to do that. I got some extra copies to give you as well. We can go through those dollars if you like.
I submitted the list from whenever we had discussed of holding this in last July. I submitted that list to Ms. Morales, and so she had it, and she was copied on it when it was originally set in July. But that was
I think I remember that. Yeah, I think I remember that.
That was the snapshot from July. We're now in February, almost March.
Paul, do you have drawings for the fire suppression system? Okay. Teal, do y'all have the drawings that he has? Y'all need to get together and get the drawings straight.
Yes, we have done drawings for that. We have not issued them to the team.
Okay.
Based on meetings with the clerk, each of the clerks to get them to a point. And we did already consider a lot of different systems.
When you say we, do you mean?
The design team.
Okay, but not with any involvement or input from the contractor?
Well, we did have some discussions with Teal about some of the dry chemical fire suppression systems, but it's been quite a while. So anyway, we have met with the clerks. I believe we have consensus with. Sorry?
We met last May.
Yes, we had consensus and meeting minutes, and we have drawings ready. But then it was decided to take some of those things out of Teal's scope of work.
I think our consideration is to put them back in right now. I mean, at least see how much it would cost to do that. That's what.
Judge, could y'all clarify something? I'm trying to find out who removed all this scope of work from Teal.
We removed it because we didn't know that we didn't know that we're going to be here in February where we're at. So these items we're going to push the schedule past where we're supposed to be complete. And so it was more cost effective to remove it, but now we're here. And
So it was like design team and removed it yourself and consulted?
no, Commissioner's Court. Well, there's a change order. We removed it.
In that change order?
Yes, sir.
Okay, that's why I guess I had a brain fog. I was trying to know, trying to figure out when it was removed.
Yeah, I can't remember what change order number, but there was a change order.
Okay. I'm sorry, what?
CCD number 7.
So are we done then?
Yeah, we'll move on to number 3, presentation of construction schedules by Teal for the remaining base scope of work and correction of non-conforming and or defective work.
Again, it's difficult for us to provide you with a completion schedule without an agreement on how the windows are going to get addressed. And whether it's the original testing protocol that's in the specifications on testing those windows, or whether it's the suggested 20% protocol that the architect has suggested, depending on what that is, then that dictates the schedule. And then upon completion of that and confirmation through however many we test or not, then that's when we're turned loose. That's when we're given the green light to finish the building. Again, by what I mean by finish the building, we're talking about the exterior wall, right? We're talking about the interior drywall that we're having to leave exposed pending resolution to the window issues. So I don't know that Mr. McComb can give you a date certain on when this is going to conclude until we have resolution and answers to those questions.
Okay, so we don't have a schedule. You brought something up. Have you punched out the outside yet? The sidewalks, the flat work, the exterior?
I mean, as Mr. Monreal pointed out, we have pre-punch lists.
Okay.
That pre-punch list was done prior to any concrete being poured. We do have our own internal, systems, QA/QC steps that we take. So there are issues or cosmetic things that we have notified the concrete contractor about that they're working through right now.
Okay.
Again, I've extended the invitation to Ms. Martinez, but you and I probably should go walk it as well so you can kind of see where we're at today. It looks really, really good.
All right, we don't have a schedule.
No, I was just gonna go over some of the numbers just to take care of the request from
So
Commissioner
that, we'll
Russo.
do that on number 4, presentation of cost estimates by Teal for remove work for the scope of work.
You ready?
Yeah.
All right. So the numbers that I've got here, and I'll hand this out. Don't look at it just yet.
If you hand it to me, I'm gonna look at it.
I know. Don't freak out right away. We'll go through it, and it'll make a little more sense. I'll email you copies. So before we look at it, we've said it ourselves as well as Mr. Bonnet during the project as it comes to change orders and the cost of change orders. This morning I went ahead and just to see what somebody else's opinion was, I went to Google and I typed in industry standard for change order amounts in commercial construction just to see what the world says is the standard. And their answer is there's no strict industry standard for change order amounts in commercial construction, but a generally accepted guideline is that change orders should represent between 5 and 10% of the total project cost. However, this can vary significantly depending on the project complexity, location, and how well the initial design was documented. So this is, we know this person, this is Mr. Google, this is what the world considers being acceptable for change orders. The original contract amount of ours was $23,615,000. If everything that's on this sheet that you're looking at that I just gave you there is incorporated into the project, the new contract amount becomes $25,342,176, which is 7% higher than the original bid value. So the 7% is right in the middle of the 5 to 10%, which we've discussed on multiple occasions in the past, and is 100% in line with what the internet says is acceptable and should be expected for commercial projects. So these numbers are all in line with it. They are a big number kind of here at the end, but this is just to kind of let you know that it is in line. So again, these numbers on here, these are just our numbers, since that's what you had asked for yesterday, what it takes to get us whole, complete, and moved into the building. These numbers do not include pricing from subcontractors who have submitted claims. Since you had not asked for that to be an entry for today, but you do have those in the past. We can resend those to you again, but this sheet here is just as it relates to what we have turned in to satisfy your request.
Claims from subcontractors, is that claims for work they've done, or is that some other
claims for
type of
time?
claim?
Claims for time, money associated with the time of the project is what those claims are for.
Not actual work?
Any additional work that they've done has been picked up in change orders. This is for the time that they've been extended out on the project, waiting for RFIs to be answered, change orders to be approved, et cetera, that has extended their scope of work out. Correct.
What does their contract say about delays?
I think you went through, I don't know, 70 or so of them in the morning is what you talked about. It's pretty clear in there. So, anyway, so here's the breakdown for what you had asked for. Our general conditions, again, we've mentioned this more than once. We've had no general conditions billings at all since January of 2024. So we're now 14 months in. Without any general conditions, this first number of $917,687 is the cost for January through mid-February, as it outlines there. Under that is the outstanding CCDs for work that's been completed but been denied on pay apps or not funded yet. Electrical powers and relays for the elevator, 11,734. Electrical disconnects on one of the first revisions for the elevators, that's 25,796. Then a change to shunt trips, also for the elevators, is 10,531. A credit for removing the shell and the plaza concrete is 8,500. Deleting the tree grading is 2876 or 2867 is a credit. This window testing, as Mr. Miller talked about earlier, that's for a week of testing, assuming that we do the 20 windows. That number comes out to the 22,500. General conditions to address all of the window remedial work on the outside of the building. That includes the drywall on the inside, the stools back, the painting, etc. Those general conditions right now go through the end of April, which is also when our builder's risk on the project is completed. So we really need to get going on that. Otherwise, we've got additional conversations to have. But that number is $133,200. And then the last two items on there are the balance on our original pay app. This is primarily funds that have been rejected in the pay application process, whether it be for brick, for EFIS, for soffits, whatever the case may be. That number is $716,469. Again, that's subcontractor money. Those subcontractors have not been funded these dollars, as we have not been. And then the retainage from the entire project, which is $1,175,754, bringing the total to get us complete, windows installed, off the job, and moved into the building. As long as all the descoped work remains descoped, the check to us would be $3,002,306.33. So that gives you kind of a screenshot of where we are, what's left to be owed to us, and then get us out of the windows and into the building. Yes, sir.
For the listening public that may be listening online, I think it's important to delineate of that $3,002,000, how much of that is above and beyond the original contract amount?
Of this three, this right here is, this would end up being $1,100,000, and that includes general conditions and the work that's already been in place and not been funded or not been billed yet.
So this is not $3 million
This
on
is-
top of the
no.
already contracted $23 million?
Correct. This $3 million includes the retainage on the original project. It includes the original dollars that have been held so far. So this $3 million is not additional. This is the total owed if we wrote a check and covered everything today.
What do you mean
That's
by
what
the
that number.
1.1 million?
1.1 million is what I'll give you another copy of this. But
That's
this
the
list
retainage.
here adds it up. Well, there's two 1 millions. 1 million is retainage and 1 million is a change order for general conditions and outstanding CCDs.
A change order you already have or a change
No,
order
a
you
change
want?
order that we've been trying to work on to get negotiated and settled and into the contract for over a year now.
So then the real number is 2 million something.
It depends on what you're asking us. What we were asked to prepare was what gets us out of here, right? That includes dollars that are already committed in the base contract, which is the retainage. And for the listening public that may not know what retainage is 5% of the total contract that is held back to ensure that we address all the punch list items and that the building is delivered. So that $3 million includes the retainage that even if any of our claims did not get approved, we would have to be paid anyway for the base scope to be complete.
But I just want to clarify though, because you keep saying 3 million, but one of those, and I don't have a paper, that's why I'm asking. The 1 million and change is for a change order you don't have and we have not agreed to.
No, that's the retainage from previous pay applications, 1.1.
She's right also. The 1 million that you're asking about is for general conditions for the last year, plus all the expenses for CCDs that have been completed and not funded, plus the work to redo the window testing after they're complete. So there's two $1 million numbers. $1 million that we've not been agreed or don't have an agreement on, and $1 million that is retained as part of the original contract.
What change order number is that?
Again, some of it's CCDs and the rest of it for general conditions is what we've been trying to sit down at the table and talk about. That's been up in the air for
I think it's important to define, especially for the listening public, the difference between a change directive and a change order.
It's kind of confusing the
Right.
way it is on there.
So whenever we first, let's say we hit the first snag, like whether it's jail standards or elevator or whatever, okay, there's a problem. Okay, well, how much is it going to cost to fix the problem? So we submit a price to fix. There's lags in time, right? Because like I was talking about earlier, that's too high, please reprice. Well, what if we change this and we do this, reprice that? So time keeps ticking as decisions don't get made to resolve a particular issue, right? And our team does our best to be able to, whenever we submit a pricing request to you guys saying, based on our critical path schedule, we really need an answer for this by X date, or else it's going to affect other tasks that happen subsequent after that, and it continues to push these things out, right? So in some instances, and on all instances after a certain point in this project, whenever we would submit those pricing requests, we would include however much schedule impact it has at the date that request is supposedly going to be accepted. And we submitted that instead of giving a change order because either the county or the architect or the owner's rep disagree with the amount of time that it takes or how much that this has impacted the schedule itself, they decided to convert those to a change directive, which is basically yes, we'll pay for the cost, but we're going to argue later on about the schedule impacts and how much you're to be paid based on the schedule impacts. So we have a long list of CCDs, which are change directives, because the county and Teal Construction cannot come to a conclusion of how their schedule was impacted from whatever the first CCD was. So it kind of just compounds and it builds and it builds and it builds. And so this is a representation of if you turned us loose today and we came to an agreement amongst Teal Construction and Aransas County, this is how much it would cost. But the longer this continues to delay and the longer that this continues to not get resolved, these numbers continue to grow. So just a point of clarification on the difference between a change directive and a change order.
I just want to say, there is a mistake in my paper for a number. I meant to say this earlier. We entered into some kind of qualified alternative dispute resolution that you authorized in September, October, November, December, and then you authorized us to move out of it. I put in my paper that we offered Teal $416,000 for their original offer of $1.2 million. We actually offered them $469,000. So that is the mistake that's in my paper. That's what we have offered. So when they're giving you this number that's in front of you, just so you know, you instructed me to make that offer, and that offer was not accepted.
Was there a counter offer?
$900,000. And then it went down to $880,000. Don't quote me on that, but we were so far apart in those, but you instructed me to offer that amount to settle this and move forward, and I did, and it was rejected.
Mike, you have something to add?
I'd really like to ask
go
if we could take a break soon.
Just a point of clarification on the change orders and CCDs was we actually went to CCDs at the request of Teal. So Teal is the one who actually requested that we just start issuing CCDs, and everybody agreed to that. So it wasn't the county or the architect decided, hey, we're just going to do it. That was at the request of Teal. So just wanted to make that point clear.
Thank you.
So on that request, that CCDs are an option in the contract that allow us to do work. That request was asked on multiple occasions by myself and some other of my teammates to try to get work done. If you give us a CCD and say, this is the scope of work that we need to do, and we're going to come to an agreement and we're going to pay you for the work that's done, great, let's go do the work. Because we were waiting so long to try to get any type of back and forth on pricing, back and forth on time, any type of agreement on a change order, then it'd have to go to Commissioner's Court, and the amount of time that it went from, okay, we're good with it, to, okay, it's executed, the work had already been done. And so the request coming from Teal was an effort to say, let us just go work. Let us get this building finished. Let's get you in this building as soon as we can, and then we can worry about the money when we get out of here, but we got to get you in. And so he's correct that request came from us and not anybody else, but it was in an effort to try to get finished and get out of here.
I think it's also important to remember as well, when it was first discovered that that the construction documents didn't meet the Texas Department of Jail Standards requirements, that they had sent comments back to the design team. Justin suggested at that time that we slam on the brakes on this project, and because he had concerns about a lot of the things that we're dealing with today, because not only was the folks at PJL and the folks at Architectus, I will give them props because they've done an incredibly good job. From what I understand, I wasn't part of any of this, but whenever the decision was made to remove the third floor from the building, they accomplished a lot in a very short amount of time, right? And it is not uncommon for things to slip through the cracks, coordination of ceiling heights and things like that. Texas Department of Jail Standards is a completely different subject. I can't think of a good excuse for that, but there was enough changes because not only are we talking about doors and hardware and things of that nature, it's how it ties to construction that was already in place, right? Because everything has to be fortified
in order for those doors to be installed properly to meet the state standards. So Justin, at that time, made the recommendation that we stop the job, get everything correct, and then move forward once everything was correct. That warning was not heeded. It was, we need to keep moving forward. And so that's the only way that we can move forward is converting. If you're not agreeing to a change request and you're not agreeing to the amount of time that it's taken to approve that change request and what that change request
You're gonna have to wrap it up.
does to the schedule, then we can't move forward, right? So we offered the suggestion of doing change directives on that so that we can continue to move the project forward. Thank you.
Commissioners?
I don't have any more, but I have a suggestion that we take a break and then we go into a short closed session.
Sounds good.
I mean, we can't do anything when we come out, but we want to talk about what we've been talking about for the last year.
All right.
Take a break.
Take a break.
And this time, did you get one of
We're on? Okay. It's 7:48. We're back in open session. Before we go to closed, sir, you had a comment. And introduce yourself and.
Yes, Judge. So my name is Matt Cano. I am an attorney and I represent PGAL. I'm probably I'm the third construction lawyer in this room. Been doing it for many, many years, but I've also, I wanted to let you all know, represented counties, governmental entities, and disputes very similar to this, and issues very similar to this about projects that got to get done or about projects that have an issue that need to get resolved. And so I wanted to just come here to say a few things. I didn't prepare anything. I didn't actually intend to talk to you all because I wasn't sure how this meeting was going to go, but I wanted to let you all know that PGAL came here today in the spirit of doing what was on the agenda, trying to get this project across what I would call the goal line for you all. They've been doing it all along, and we didn't come here ready to confront and controvert allegations that are somewhat amorphous about design issues. But I want to let you all know that we would be able to do that if we had to. We don't agree that there are design issues. There are issues with locked doors, and we understand that, and that's an issue that can get resolved. But we don't agree with a lot of the other things that have been said about bricks and windows and things, but we're not here to talk about that. What I do want to say, though, when I heard a comment a minute ago about how PGAL has requested that they be exonerated of all liability for the window issue with the city. And that was what the letter said that was sent to Teal. I've got the letter right here. The word exonerate is not in there. The word hold us not responsible is not in there. It gives a nine item, point-by-point recitation, one of which is to give us a detail prepared by your consultant to correct what we call non-conforming work. And That's not even been done yet. We don't have a detail from ABB, the Nicastro company that you've heard about. We have a detail prepared, I believe, by Justin McComb of Teal, which is based on the words in the report, and we want that to be sure. So that's one of the items. Give that to us, please. But most importantly, I guess where this exoneration idea comes from is this letter says, give us the same warranty that the city, give the city the same warranty the city was entitled to under your contract from all the manufacturers of all the sealants you're putting in there. That's what you bargained for. That's what you should get. So yes, there is something to correct what we call non-conforming work, which was identified in the 06 consulting report prepared on behalf of Teal and then abandoned by them, which is fine. You can get a different consultant who says a different thing, but get the work corrected, get the windows in there so that the city doesn't have to have a window leak as you contracted to do originally. So all I can say is we could go point by point on things. I'm not going to do that. I don't think we should do that. What we're trying to do is get your project completed, get your project where it needs to be, get you, who have to talk to the members of the community, to do the thing that needs to get done. And so you can tell the members of the community, we kept you in mind and we got this project done. Thank you.
All right, thank you. And I apologize, I didn't let you speak earlier. I wasn't trying to ignore you, I just didn't see you.
I wasn't
Thanks.
planning on speaking, Judge,
Okay.
but I figured out at least
Thank
something.
you.
Do you need a card?
Yes, please. Thank you.
All right, well, motion to go into closed session?
Fine. Wait. Okay. There's one in there somewhere. Get past the,
Read the whole thing.
get past all of the things that are in there otherwise.
Someone want to read it? I'll read
Okay,
it.
we'll be in the hallway if anyone.
All
needs
right, well, I
talk
move to
us.
convene into a closed session pursuant to section 551.071 of the Texas Open Meetings Act to consult with counsel and receive legal advice about pending or contemplated litigation. These will help. A settlement offer or other attorney-client privilege matters in which the duty of the attorney to the governmental body under the Texas Disciplinary Rules of Professional Conduct of the State Bar of Texas clearly conflicts with the Open Meetings Act regarding the downtown Anchor project.
Second.
Got a motion and a second.
Commissioner Cheney?
Aye.
Commissioner Castellano?
Aye.
Commissioner Russo?
Nay.
Commissioner Dutnick?
Aye.
Judge Garza?
Aye. We're going to go into closed session, and I'll come get y'all in the fishbowl.
Can open session?
I'll second that.
Got a motion and a second?
Commissioner Cheney?
Aye.
Commissioner Casterline?
Aye.
Commissioner Russo? Aye. Commissioner Dupnick?
Aye.
Judge Garza?
Aye, we're in open session.
Move to adjourn?
So can we ask Paul if he's gonna send us that paperwork on the windows? You're gonna send us that stuff on the windows that you were talking about, that you sent the city, or?
Yes, I will. I'll prepare a letter that's going to have the same requirements on it that we're doing for the city. Yes.
When do you think we'll get that?
Monday at the latest.
Okay.
Tonight, if I get
Monday's
home and
good.
send it out in an email. But yes, very soon.
All right.
Commissioner Russo? Aye. Commissioner Dupnick? Aye. Judge Garza?
Aye, we are adjourned. Thank y'all. We'll have another meeting here soon.
Is that a promise or So I noticed KC left before you were done. Couldn't take it.